Hello, everyone, and a very warm welcome to Cognito Key. I'm so glad you could join me.
Today we're going to tackle a really interesting question, one that probably affects all of us more than we realize. When is a promise not really a promise in the eyes of the law?
Think about it. Maybe you've made a handshake deal with a friend, or just a casual promise. Have you ever stopped and wondered, hey, is this actually legally binding? Like, could it hold up in court? Well, you're in the right place because today we are getting to the bottom of exactly that.
All right, so let's dive right in. The main thing we need to wrap our heads around is this term, a void agreement. What on earth does that actually mean?
So in the eyes of the law, a void agreement is basically an agreement that's completely unenforceable. What that means is it doesn't give you any legal rights and it doesn't place any legal obligations on the other person. It's pretty much a non-starter from a legal point of view.
To put it even more simply, it's as if the agreement never even happened. It has absolutely zero legal power, right from the very beginning. But why? Why does the law just ignore certain agreements? Well, let's break down the common problems that can make a deal void right from the get-go.
First up, problem number one. This is a big one. It's all about who is making the deal. You see, the law is actually quite picky about who it considers eligible to make a binding agreement.
For example, any deal made with a minor, that's someone under 18, or a person who is considered to be of unsound mind is immediately void. Same goes for someone who's disqualified by law, like certain convicts. And this isn't just some random rule, It's actually a really important safeguard. The whole point is to protect people who might not fully grasp what they're getting into.
Okay, so we've established that the people making the deal are super important. But what if everyone involved is perfectly eligible? Well, that brings us to our second big problem, agreements with flawed aims. The law just won't touch a deal if its whole purpose is problematic.
Let's look at a great example. Imagine Daniel, a cafe owner, pays his competitor, Ron, 20 lakhs to just shut down his business in the area. This is a classic case of what's called restraint of trade. The law sees this and says, no way. Why? Because it kills healthy competition, which is bad for everyone. So, that agreement? Totally void.
And here's another one. Robin agrees to marry only Steffi, but only if her dad gives him 2 crores. This is an agreement in restraint of marriage. You just can't make a legally binding deal that restricts someone's freedom to marry who they want. So Robin can't enforce this promise at all, because the law is all about protecting a person's right to choose freely.
And it doesn't stop there. Really, any agreement with an unlawful goal or something that goes against public policy, like trying to create a monopoly or preventing someone from going to court, all of these are considered void right from the start. The theme is pretty clear, right?
Okay, on to our third and final problem area, promises that just don't count. Sometimes, it's not about the people or the purpose, but the actual substance of the promise itself. The terms are just so flawed that the law can't do anything with them.
Take a look at the 2 cars problem. This is a perfect example of what lawyers call a bilateral mistake. So Vicky thinks he's buying Frederick's shiny new car. But Frederick, he's planning on selling his old car. See the problem? They're not on the same page about the most basic part of the deal. Since there's no real agreement on what's being sold, the whole thing is void.
Clarity is everything. So here, Joe agrees to sell 10 kilograms of lentils to Ben. Sounds simple, right? But wait, which kind of lentils? Mung, Masoor, Urad? Because it's not specified, the agreement is just too uncertain, too vague for a court to enforce. Now, if Joe only sold one type of lentil, that would be a different story. But as it is, that uncertainty makes the deal void.
And then there are wagering agreements. This one's easy. A bet is just a bet. Whether you're betting on a cricket match or if a class will be canceled, these agreements have zero legal standing. The courts just won't get involved in helping you collect your winnings.
And just 2 more quick-fire examples for you. An agreement with no consideration, that's a legal term for something of value being exchanged, is usually void. A one-way promise generally doesn't count. And, pretty obviously, an agreement to do something that's totally impossible, yeah, that's void too.
Okay, before we finish up, I want to make one really important distinction. People throw around the words void and illegal like they're the same thing, but legally speaking, they are very, very different.
So what's the difference? Well, an illegal agreement is something the law explicitly prohibits. Think of a contract to commit a crime. That's illegal. A void agreement, though, isn't necessarily forbidden. It's just unenforceable. The law won't help you with it because of one of those flaws we just talked about. So here's the key takeaway, the one thing to remember. An illegal agreement can land you in actual trouble. A void agreement, it just gets ignored. It's almost like it's invisible to the law. It's a promise that the legal system just pretends isn't even there.
And that brings me to a final question for you. Now that you know all this, think about your own life. What agreements have you made? Those casual promises, those handshake deals, which ones might actually be, well, invisible to the law? It's definitely something to think about, isn't it?
I really hope you found this explainer helpful. If you did, and if you enjoy making complex topics simple, please do subscribe to Cognito Key. And hey, don't forget to like this video and share it with anyone you think might find it interesting. Thanks so much for watching.